meeting to order. Casey Griffin on our staff will call the roll to establish a quorum.
Mr. Cobbins. Mr. Darnell.
Here.
Mr. Eby.
Here.
Mr. Ferguson.
Here.
Mr. Hamby.
Here.
Mr. Jensen. Ms. Kim.
Here.
Mr. Mullenauer.
Here.
Mr. Morrow.
Here.
Madam Chairman.
Here.
Madam Chairman, I count 8 members present.
Thank you. We have a quorum present and are duly convened. And without objection, Mr. Jensen and Mr. Cobbins are excused. At this time, it is my pleasure to introduce and officially welcome our newest board member, Mr. Jordan Mullenauer. I'm going to read a part of his bio because it's quite lengthy and impressive, but I will just be as brief as possible and do justice to his credentials. Mr. Mullenauer was appointed by Governor Lee in November 2021 to represent the 2nd Congressional District. He earned his bachelor's degree, his MBA, and law degree from the University of Tennessee, Knoxville, and recently graduated from the Wharton School, earning his executive MBA. He began his working career at the ripe old age of 12 and started his first business at 16. He and his business partner founded a privately owned investment company, Mullenauer Gross LLC, in 2004, and together they have since started and acquired or invested in numerous businesses throughout the United States, with several relocating to Knoxville. Jordan, his wife Christina, and their 4 children remain actively involved in the Knoxville community, their church, a variety of social impact organizations, and Jordan serves on the boards of the Trinity Health Foundation, the East Tennessee Historical Society, and the Knoxville Chamber. Jordan, we look forward to serving with you. You're welcome to make a few remarks. It's not
Madam Chair, and it's great to see everybody this morning. I'll cede the time to our discussions today, but I thank you for the warm welcome.
Great, thank you very much. I also want to inform you all that Dr. Amy Owen is standing in for State Board Executive Director, Dr. Sarah Morrison, while she is on leave due to the birth of her newest child, a baby girl, Virginia Townley Morrison, who was born January 19th. Proud parents and brothers happily welcomed her a few days ahead of schedule. Now, it's also my pleasure to recognize an important educational accomplishment and milestone for Deputy Executive Director of Policy and Research for the State Board of Education. Amy Owen earned her doctorate in Public Policy and Administration from Tennessee State University. So please join me in congratulating Dr. Amy Owen on this accomplishment. We know she worked very hard and long to achieve this degree.
Thank you all, and thank you, Madam Chair. I really appreciate it.
Now I'm going to turn to Dr. Owen, who will provide a few highlights from yesterday's workshop session. Dr. Owen?
Thank you, Madam Chair. We were able to convene in person in Nashville yesterday, which was very exciting to get to see everyone before the weather came in. We met early in the morning at the Senate chambers, where Mr. Mike Edwards, our departing board member from the 2nd Congressional District, was honored at the Senate with a resolution sponsored by Senator Massey and Briggs. So we were able to have that event and to spend time with Mr. Edwards and his wife after his 10 years of service on the board. We then moved into a very lengthy workshop. I appreciate all of your time and attention yesterday. We had several guests join us to present, including Zachary Adams from the Tennessee Board of Regents, who talked about trends in statewide dual credit courses and some new courses that are being created and updated. We also heard from Dr. Susan Patrick of the Tennessee Education Research Alliance about trends in promotion and retention data over the past 10 to 12 years. We then had several colleagues from the Department of Education join us. 2 spoke about items that you will consider today. Martha Moore gave us information on revisions to the strategic compensation policy, and Scott Intermule talked about the residential mental health facilities rule that's on final reading today. Megan McElroy also provided a very appreciated update on the extensive stakeholder outreach that has occurred with regard to education funding and some broad strokes of potential plans for updates to the education funding formula. And finally, on our staff, Allie Gaffey provided 2 presentations on charter school authorizer evaluation results, which is an item on final reading today, and also a quick update on the state board's master plan at its midway point in the year. And I know she'll have follow-up conversations with each board member as well. So it's a very busy workshop day, and then I'm glad you all were able to get home safely as the icy rain came in. Thank you, Madam Chair.
Very good. Thank you, Dr. Owen. I now call on Angie Sanders to read the statement of necessity to conduct this meeting electronically.
Thank you, Madam Chair. Pursuant to Tennessee Code Annotated Section 844-108B3, the State Board makes this determination of necessity for its regularly scheduled board meeting today at 9 a.m. TCA Section 49.1.301 requires the State Board to meet at least quarterly. Due to the potential for inclement weather on the date of this regularly scheduled quarterly meeting, and to ensure that State Board members, staff, and the public could avoid potentially hazardous travel conditions on the morning of the meeting, State Board made the determination that this meeting should be conducted electronically. This meeting includes consideration of a number of revisions to State Board rules and policies, as well as educator preparation program provider approvals and approvals of final charter school authorizer evaluation reports. Notice of this meeting was posted on the board's website, along with the agenda and instructions for accessing this WebEx. And with that, Madam Chair, I will turn it back over to you.
Thank you, Ms. Sanders. Now let's begin with the approval of the consent agenda item 1. Is there a motion to approve?
Madam Chair, this is Bob Eby. I so move.
Mr. Eby moves. Is there a second?
Madam Chair, Nate Morrow, second.
Mr. Morrow provides the second. This requires a roll call vote. Casey, would you please call the roll?
Mr. Cobbins, Mr. Darnell,
Aye.
Mr. Eby,
Aye.
Mr. Ferguson,
Aye.
Mr. Hamby,
Aye.
Mr. Jensen, Ms. Kim,
Aye.
Mr. Mullenauer,
Aye.
Mr. Morrow,
Aye.
Madam Chair.
Aye.
Madam Chair, I counted 9 ayes.
The ayes have it and the motion is approved. Thank you. Moving into report items, I have 2 to report. I will try to be brief, but I will indicate first and foremost that we did receive some excellent updates in our State Board of Education Preparation and Licensure subcommittee. Actually, it's now called Study Committee. And I do want to do justice to those reports. So I'll give you certainly high level because it was very excellent reports that were given to us that day. We met on January the 27th and began the meeting by hearing updates from the department by Mr. Michael Durline, specifically on ed preparation literacy standards implementation. He shared the requirements of EPPs to begin providing reading instruction training on the foundational literacy standards for K-3, general and special education on August the 1st, 2022. And these include how to effectively teach the literacy skills, how to scaffold instruction for teaching students with advanced skills and students with significant deficiencies, identifying characteristics of dyslexia and effective instruction, implementing high-quality instructional materials, behavioral management through trauma-informed principles, and administration of a universal reading screener. Mr. Durline also provided EPP literacy standards accountability, specifically which is something that includes a new signed assurance process whereby EPPs will attest implementation, complete evidence of such by documenting their work via matrices, and how they will integrate EPP foundational skills standards in each applicable program. Next, we received a presentation on teaching as a profession from Dr. Jean Luna, based on questions and interest in knowing more from board member Nick Darnell about teaching as a profession courses offered in high school. Dr. Luna provided a listing of classes offered for teaching as a profession and new classes under development and considerations for recruiting educators to teach these courses. It was also noted that teaching as a profession is an elective course and that districts do not have to offer it. After discussion, committee members will consider the board's role regarding the recruitment of teachers, and as always, full board input is welcomed. Next, Erica Light provided updates on the Ed Preparation Report Card. The report card is scheduled for release to the public on February the 15th, but please note that Ed Prep providers receive their individual reports on February the 1st, as is customary for their review in preparation to respond to any questions or comments they may receive. Two new areas that will be included in this year's report card are a listing of endorsement areas by type and a new employment map for each Ed Preparation program designed and developed by our very own Ms. Light. The map reflects the number employed in each county for their specific EPP. Erica also provided an update on EdTPA results, conclusions from them, and recommendation regarding EdTPA cut scores from analyzing this data. The recommendation is to keep the current cut score rather than raising scores to 42 on most subjects. And the next item 2B is appointment of members to the 2022 study committees. The state board will have 4 study committees on key priorities related to our education priorities in 2022. So based on your areas of interest noted in your survey provided by the staff, appointments and chairmanships have been made by me as chairman. Career and Technical Education and Workforce Development is a new study committee for 2022, and I'm pleased to appoint our newest board member, Mr. Jordan Mullenauer, as chair, and to appoint Daryl Cobbins, Larry Jensen, and Garen Hamby as members to that committee. I will continue to chair the Ed Prep and Licensure Study Committee and appoint Bob Beebe, Nick Darnell, and Jordan Mullenauer as members to that study committee. Mr. Nate Morrow will continue to chair Literacy, and members Daryl Cobbins and Gordon Ferguson will be a part of that subcommittee. Mr. Eby will continue to chair Testing and Accountability, and Nick Darnell and Elisa Kim will serve as members. This concludes my reports. Before we move to items on first reading, several reminders. All votes today are by the call of the roll. Presenters, please state your name and title for the record, and board members, as always, please address the chairman to be given the floor to speak. Again, this is to avoid members speaking over one another. Thank you. Moving into items on first reading, policy. The first one is 3A, Personnel Policy 1.300. Ms. Angie Sanders.
Thank you, Madam Chair. Angie Sanders, General Counsel for the board. I'm presenting to you on first reading amendments to Personnel Policy 1.300. In 2020, the board revised this policy to formalize a delegation of authority to settle both administrative legal matters filed under the Uniform Administrative Procedures Act and legal matters filed in state and federal courts. These revisions further clarify the process for final approval of any settlement by clarifying that settlement of matters filed in state or federal court are subject to final approval of the Attorney General and others in alignment with state law, and that settlement of administrative legal matters is subject to final approval by the board by placing that on the consent calendar. Happy to answer any questions that you all have about these changes. Thank you, Madam Chair.
Are there any questions for Ms. Sanders? Hearing none, is there a motion to approve this item?
This is Gordon Ferguson, so moved.
Mr. Ferguson provides the motion. Is there a second?
This is Jordan Mullenauer. I second.
Mr. Mullenauer provides the second. Any discussion? Mr. Griffin, would you please call the roll?
Mr. Cobbins.
Aye.
Mr. Darnell.
Aye.
Mr. Eby.
Aye.
Mr. Ferguson.
Aye.
Mr. Hamby.
Aye.
Mr. Jensen. Ms. Kim.
Aye.
Mr. Mullenauer,
Aye.
Mr. Morrow,
Aye.
Madam Chairman.
Aye.
Madam Chairman, I count 9 ayes.
The ayes have it and the motion is approved. Thank you, Ms. Sanders. Moving to item 3B, Universal Screeners and State Adoption Benchmark Assessments Rule. Ms. Angie Sanders, you're up again.
Yes, ma'am. Again, Angie Sanders, General Counsel for the Board. I'm presenting to you on first reading amendments to the Universal Screener and State Adopted Benchmark Assessments Rule. The Literacy Success Act of 2021 requires LEAs and public charter schools to annually administer a universal reading screener to each student in kindergarten through grade 3 during each of the 3 administration windows established by the department. In July of 2021, the board approved this rule as well as corresponding policy 3.302 containing the list of state-approved universal reading screeners based on recommendations that were made by the department. In order to be recommended for approval, these screeners had to be included in an LEA or public charter school's foundational literacy skills plan, and they were required to meet specific requirements set forth in this rule. This item proposes additions to the rule to specify the process to remove a universal reading screener from the list of state-approved screeners contained in policy 3.302. If a universal reading screener does not continue to comply with the requirements set forth in the rule, and as a result places LEAs or public charter schools that utilize that screener out of compliance with the Literacy Success Act, the State Board may recommend removal of the screener from the approved list contained in policy 3.302 in accordance with the procedure set forth in this rule. We will hold a rulemaking hearing on this rule to collect more public feedback before bringing it back to the board on final reading. And with that, Madam Chair, I am happy to answer any questions that you all have.
Are there questions for Ms. Sanders?
Madam Chair, Bob Eby.
Yes, Mr. Eby?
Yes, Angie, I got a question on D3. It says, if the LEA or public charter school does not come into compliance with this rule, blah, 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 by delivery of the mid-year performance report or by delivery of the end-of-year performance report, should that say then whichever comes first? Or I don't understand. You got 2 different time periods there.
I believe the intention was in that because there's 2 different reports that we're anticipating that the department would be providing, there may be a situation where they're in compliance in the first report, and then when we get the second report, we see that they've fallen out of compliance. There may also be a situation where maybe they're out of compliance on the first administration, so by the time we get that report, but then they come into compliance by the final report. So it just, I think, may be a situation where they're either coming into compliance or they're falling out of compliance, and those reports will give us a good picture of how that's working.
Then why wouldn't it say just within compliance by the final report? Maybe I'm wrong. Maybe other board members don't have this issue. It's kind of confusing to me.
I think the intent was to provide us some flexibility given that we weren't sure with how things were going to shake out. But we can certainly continue to look at that and see if we need to make some tweaks to that language between first and final reading.
Yeah, I'd like to do that just to understand a little bit clearer, what we're saying there. So, let's look at that between first and second reading. Thank you.
So just, Bob asking that, excuse me, Nate Morrow.
Mr. Morrow?
Thank you. So we want compliance with both reports, and what you're saying is, and so I guess if they're out of compliance for either report, that flags them, but do they have by the next report to then come back into compliance? Is that what it's saying?
The way that I understand it is the department is going to be monitoring whether or not these vendors are reporting information to the Department of Education so that these districts can maintain compliance with the law. If there are issues that they're seeing after these administrations, Those will be included in the two different reports. One's a mid-year performance report, and then one will be sort of an end of year after all three administrations are over. So if they are out of compliance with one of the first two, that would probably, I believe, pop up on that mid-year report.
Okay.
And then if they're out of compliance with the last one, it would pop up on the last report.
Okay.
I think the idea is to give us some flexibility that if we're seeing that they are out of compliance at the beginning and they haven't come back into compliance, there would be the ability to make a recommendation to remove them from the list.
Yeah, I kind of agree with Bob. Just maybe a simpler way of saying what you just said it in a clearer way than I think it's written.
Yeah, we can work with the department to try to figure out a way to clarify this and get our arms around what this process will look like in, actual practice so that we can make it clear.
Just the simplicity of they need to be in compliance as they do 2 reports a year. One, and by the end of the second time that it's evaluated, you need to see they have to be in compliance or they're no longer eligible to be a universal screener. That's just.
I have a follow-up to that, so I want to be sure that I'm clear on this. Would we then receive recommendation to remove a vendor mid-year, or would we wait till the end of the school year in order that the district would then be able to continue and finish the year out with that vendor, as opposed to having to scramble to implement a new vendor and train all of their personnel on the new screener? So can we clarify that? And it may be clarified here, but I just want to be sure. Point me in the direction of where that's laid out. And I think it does piggyback on what was said by Nate and Bob.
Madam Chair, this is Bob. That was the second part of my question too, is that if you look at it, we would then vote whether to remove them or leave them in. And so the question is, what recourse does the district have if we remove them? And it gets into your point from the timing standpoint. So
I think ideally it would happen at the end of the year to give them time to find a new vendor before the next school year begins. The other thing we need to think about is the way that this process is set up, that we wouldn't necessarily make a recommendation to remove on like the first time we know they're out of compliance, because this rule says that the department will provide a letter basically letting the district and the vendor know that they're out of compliance and that they need to remedy that non-compliance to make sure that they are able to come back into compliance, essentially. So there's got to be some time period for them to try to fix it before we would make a decision about whether or not something needed to be removed from the list. If that makes
Well, I'm going to jump in because you said ideally we would do it at the end of the year. I don't think we should be placing it on ideals. I think we should be specific, and I think we should seriously recommend or consider that it's at the end of the year because of the extreme disruption. Because all of a sudden, in the middle of the school year, you have a district without a screener that's no longer in compliance, and they have to scramble to implement the newest one. And that involves training and a lot of other work on their part. So I strongly suggest that we add language that makes it at the end of the year so that they have time to implement a new screener by the new year if they're not in compliance.
Yeah, we can definitely look at that. I think that's a great point, Madam Chair.
Thank
And
you.
we'll talk with the department about that too. I'm not sure if they have any additional thoughts on this process.
Angie, I appreciate that. Can you all hear me? I will go ahead and jump in now, but I want to make sure everyone can hear me. Jack Powers with the Department of Education. And thank you for the questions, Madam Chair and Vice Chair. I do just want to kind of clarify the way that this rule is written. First and foremost, I want to point out that when it comes to communication and just any interaction, it's very clearly with the districts. I just want to kind of make that point clear when it comes to any interaction that we have related to these screeners, it is with the districts. And one of the reasons for that is because, we are not working with the vendors here. The districts have contracts with the vendors, which I think is important to keep in mind. The districts are the ones that are really working closely with vendors around timing, around ensuring that the mode of delivery for these screeners is conducive to meeting the deadlines for these screeners that are specified in statute. When it comes to this rule, we have 3 screening administration windows. The way that we have tried to set this up and to clarify this conversation around mid-year or the end of the year, the way that we have tried to set this up is to have 2 reports and allow for potential action to be taken after either of those reports. If we administer, or if a district administers a screener in the first window, and then through the kind of information gathering after that first screener, potential issues arise, there needs to be an option that we can, or that there needs to be an option to remedy those errors in the middle of the year. However, as Angie mentioned at the beginning, there could be a scenario where the first administration goes well and that issues don't arise until the second administration. In that case, we wouldn't have that information until closer to the end of the year. So we also need the option to take action at the end of the year. And that's what we were trying to accomplish with the way the language is written. I'll echo what Angie said about our willingness to continue obviously to work between first and second reading if we need to kind of clean that language up to make it more clear. The other thing I want to make sure to mention here is, just as a reminder, there's the free Tennessee Universal Reading Screener option as well that districts can use should there be issues either at the middle of the year or at the end of the year. I hope that's helpful.
Does anyone have a follow-up question for Jack and other questions? Because I have several, but I want to wait to provide each member an opportunity to ask theirs. Okay. Thank you, Mr. Powers. I do want to note that I do recommend that in the definitions area that we add Literacy Success Act and learning loss and remediation definitions to the definitions section. This would just make it easier, I think, for the reader not to have to go back and research, remind myself what is each of these acts, what do they include? So I recommend that. And I've recommended some other structural changes that we do not need to get into at this juncture. But I do want to ask that we look at page 4. This is of the red line version. Item 3, line 5, where we are noting here that we are recommending the executive director to report the number of vendors who are out of compliance and seek the board's approval to remove those vendors from the list. So I want to really understand why we are asking the state board executive director to take this responsibility as opposed to the department, who has all of the interactions with the LEA, and even perhaps, I don't know if you have that interaction with the vendor, but certainly with the LEA. And in your role as compliance, I believe that this would be better served by the department reporting this to us for removal, particularly because you're having a lot of engagement with the LEA and you understand all the nuances, all the challenges, all of the details related to how you came to this decision. So I would recommend that that be changed, but I'm certainly willing to hear the rationale for it being state board as opposed to TDOE.
Madam Chair, I'll let Jack Powers from the department answer that.
Thank you.
There we go.
Jack.
Just having trouble unmuting myself. Forgot about just the spacebar trick. So I think it's important to, again, clarify that, the department is not working with vendors. The vendors are entities that are contracting with districts, and the districts are responsible for ensuring that the deadlines in the law can be met. And the districts are responsible for all of the other things that would go into the contract with the vendor. And of course, we can't make any decisions that would force districts to, adjust those contracts. And so therefore, we're not making those decisions. We are providing objective information to the state board upon which to make that decision.
So just for a point of fact, the recommendation to approve the vendors comes from the department. And it's our understanding, from what I recall from when that list was submitted to us, that the department does go through a process of vetting those vendors and allowing those to be submitted to the state board for approval. And because the approval becomes from the department, I would recommend that the removal recommendation come from TDOE as well, because of the reasons I just stated.
Madam Chair, we can commit to continuing conversations with the department between first and final reading to see what we can come to an agreement on.
Thank you. I appreciate that. Are
Madam
there
Chair,
other? Yes,
Ms.
Ms. Reevy.
Yeah, I just want to follow up on what you were saying, just so I understand. So the districts are working with the universal screeners. The universal screeners are required to submit to the department data that then the data uses. And if that data is not appropriate, then the department notifies us that the universal screener is out of compliance. Is that how the process works? I mean, they notify the district that they're out of compliance, and they go through the process of either bring them back in compliance or whatever. But how does the Board of Education get the information that they are out of compliance, and then for us to take action? Does that come from the department, or does that come from the districts, or what?
I can try to answer that question, Bob, and then Jack, if you need to jump in, let me know. The way that the rule's currently structured, the letter that the department would send to the district, letting them know that they're out of compliance, would, I believe it's right now saying it copies the chair of the state board. We've already discussed maybe we might need to change that to the executive director if the way the rules, if the rule stays the way it currently is, with her being the one that makes the recommendation. So that notice of non-compliance would CC the chair of the board, and then you all would also be getting those mid-year and end-of-year reports that we were discussing that provides more information about the issues that the department is seeing.
So the question that the chair is bringing up is that if our decision to remove them as a universal screener comes because of the information that we're getting from the department, does it make sense for the department to make that recommendation as opposed? Okay, so yeah, have that conversation with the department and come back to us between first and second reading. I think I understand the process a little better now. Thank you.
Any other questions or comments? Hearing none, is there a motion to approve?
Madam Chair, this is Bobby. Yeah, I'll move for approval with the stipulation that we will look between first and second reading some of these issues.
Mr. Eby provides the motion. Is there a second?
Nate Morrow, second.
Mr. Morrow provides a second. Any further discussion? Mr. Griffin, would you please call the roll?
Mr. Cobbins,
Aye.
Mr. Darnell,
Aye.
Mr. Eby,
Aye.
Mr. Ferguson,
Aye.
Mr. Hamby,
Aye.
Mr. Jensen, Ms. Kim,
Aye.
Mr. Mullenauer,
Aye.
Mr. Morrow,
Aye.
Madam Chairman.
Aye.
Madam Chairman, I count 9 ayes.
The ayes have it and the motion is approved. Thank you, Ms. Sanders. Moving to item 3C, School Attendance Policy 4.00, Ms. Catherine Johnson.
Thank you, Madam Chair. Catherine Johnson, Deputy Director of Academic Policy for the State Board. This item is to move school attendance policy 4.100 into alignment with Public Chapter 116 of 2021. It will add participation in a 4-H sponsored event or activity as a circumstance in which a student must be counted as present. I'm happy to answer any questions members may have.
Are there any questions for Ms. Johnson? Hearing none, is there a motion to approve this item?
This is Nick Darnell. I so move.
Mr. Darnell provides the motion. Is there a second?
Garrett
Ferguson.
Hamby, second.
Mr. Hamby provides the second. Mr. Griffin, would you please call the roll?
Mr. Cobbins,
Aye.
Mr. Darnell,
Aye.
Mr. Eby,
Aye.
Mr. Ferguson,
Aye.
Mr. Hamby,
Aye.
Mr. Jensen, Ms. Kim,
Aye.
Mr. Mullenauer,
Aye.
Mr. Morrow,
Aye.
Madam Chairman.
Aye.
Madam Chairman, I count 9 ayes.
The ayes have it and the motion is approved. Thank you, Ms. Johnson. Item 3D, professional assessments for Tennessee Educators Policy. Erica Light.
Good morning, Madam Chair. I'm Erica Light, Director of Research for the State Board of Education. The item before you today on first reading is regarding the professional assessments for Tennessee Educators Policy 5.105. As you all know, to become a licensed educator in Tennessee, state law and state board rules require individuals to demonstrate both content and pedagogical competencies through assessments. The pedagogical assessment required for most licensure areas is the EdTPA. Currently, this policy states that the qualifying score for the EdTPA pedagogical assessment will increase on January 1st, 2023, and it would increase to a score of 42 for most subject areas. This item proposes to eliminate this scheduled increase in the EdTPA qualifying score and to maintain instead the current qualifying score. Even without the scheduled increase, Tennessee will have one of the highest EdTPA qualifying scores in the nation. Justification for this is related to the need to account for measurement error when setting a pass-fail qualifying score for licensure. This need is acknowledged by the developers of EdTPA, which are the Stanford Center for Assessment, Learning, and Equity, or SCALE. SCALE were the ones who recommended the specific score of 42 as the professional performance standard for most subjects in EdTPA, but they also note that, as with all assessments, there is always some degree of measurement error. And particularly in the current context of teacher shortages, we do not want to have people excluded from the classroom due to a small amount of measurement error in their assessment. During the 2019-20 academic year, for example, 85 fewer teacher candidates in Tennessee would have passed EdTPA if the qualifying score had been at SCALE's recommended standard. There are a few additional edits to this policy, including clerical revisions to bring the policy in alignment with the educator licensure rule, and clear notation of the phase-out dates for certain licensure assessments that have been replaced by newer versions. I will note that prior to final reading, we will add more clarity about the deadline for candidates to take these assessments that are being phased out. Currently, the policy in the red line copy that you have only shows the final date that they can submit them for licensure, but there's also a final date on which they need to have taken the assessment in order for it to be accepted. And at this time, I'm happy to take any questions.
Are there any questions for Ms. Light? Hearing none, is there a motion to approve this item?
This is Jordan Mullenauer, so moved.
Mr. Mullenauer provides the motion. Is there a second?
I'll second Gordon Ferguson.
Mr. Ferguson provides the second. Mr. Griffin, would you please call the roll?
Mr. Cobbins,
Aye.
Mr. Darnell,
Aye.
Mr. Eby,
Aye.
Mr. Ferguson,
Aye.
Mr. Hamby,
Aye.
Mr. Jensen, Ms. Kim,
Aye.
Mr. Mullenauer,
Aye.
Mr. Morrow.
Aye. I'm used to going after Kim.
Madam Chairman,
Aye.
Madam Chairman, you have 9 ayes.
The ayes have it and the motion is approved. Thank you so much, Ms. Light. Moving on to item 3E, Civil Rights Compliance Rule. Ms. Hersey.
Good morning, Madam Chair and members of the board. Thank you for having me here today. My name is Chandrea Hersey, and I am a staff attorney with the Tennessee Department of Education. I'm here to present the Civil Rights Compliance Rule. All recipients of federal financial assistance from the U.S. Department of Education must comply with federal civil rights laws, Title VI of the Civil Rights Act of 1964, and Title IX of the Education Amendments of 1972. This item presents a new rule outlining the department's oversight and investigation processes when ensuring compliance with these two federal laws. This rule ensures consistency and transparency regarding department responsibilities in responding to complaints arising under Title VI and Title IX, and the State Board approved a version of this rule on first reading at the July 23rd, 2021 quarterly meeting, but significant revisions have been made to this rule since first reading, and it is being proposed on first reading again to allow for another public rulemaking hearing on this version of the rule. The Department of Education recommends acceptance on this item on first reading, and the State Board of Education staff concurs with this recommendation. And with that, I'm happy to answer any questions you may have.
Are there any questions for Ms. Hersey?
Madam Chair.
Yes. Mr. Mullenauer?
Thank you. I had just a couple of questions. One is, and this had come up in one of our pre-briefing calls, just a minor typo in the definition of complainant. If you could take a look at that. And then I think more importantly, I'm going to go to section, let's see, it's 04.01 subsection 2. There's a, I'm sorry, subsection 0.04, 04.05, sorry. There's a commentary around confidential information, and we had a dialogue internally about whether or not the confidential information would apply also to teachers in some fashion. I believe the explanation that had been given was that it was subsumed by number 6 under that same subsection that references the Tennessee Public Records Act, but that appears to apply only to the student's record information. Is there a mechanism in this rule to also make sure that we are taking into account the teacher's confidential information? I imagine that there will be sensitive information that might come to light in these investigations.
That's something that we didn't originally incorporate into this rule, but it could be something that we consider as far as a revision between first and final reading for this rule.
Stakeholders that would need to be accounted for in that same way, or would it just be students and teachers?
With our current process, the protections that are provided are under the federal law as far as student privacy or the Student Privacy Act. So that would be the information that is normally going to be redacted from any kind of documentation that we send out, and any additional information that may be included about community members or additional stakeholders would be subject to the Tennessee Public Records Act. But we can make considerations on first and final reading on how additional information may be redacted or kept private if needed.
Okay, thank you.
Other questions or comments? Hearing none, is there a motion to approve this item?
So moved, Daryl Cobbins.
Mr. Cobbins provides the motion. Is there a second?
Bob A.B. seconds.
Mr. Eby provides the second. Any further discussion? Mr. Griffin, would you please call the roll?
Mr. Cobbins,
Aye.
Mr. Darnell,
Aye.
Mr. Eby,
Aye.
Mr. Ferguson,
Aye.
Mr. Hamby,
Aye.
Mr. Jensen, Ms. Kim,
Aye.
Mr. Mullenauer,
Aye.
Mr. Morrow,
Aye.
Madam Chairman.
Aye.
Madam Chairman, you have 9 ayes.
The ayes have it and the motion is approved. Thank you, Ms. Hersey. Item 3F, Educator Licensure Rule, Mr. Michael Durline.
Good morning, Madam Chair and board members. I am Michael Durline, the Senior Director of Educator Licensure and Preparation at the Tennessee Department of Education. The State Board of Education Educator Licensure Rule governs the issuance, renewal, advancement, and reactivation of all educator license types. Section -.11 governs endorsements issued on educator licenses. This rule addresses revisions that are necessary to implement the Tennessee Literacy Success Act of 2021, which mandates that beginning August 1st, 2023, educators seeking licensure and endorsement in specific areas must either complete an approved foundational skills professional development opportunity or pass a foundational skills literacy assessment. We have made revisions to this rule to address licensure issuance, renewal, advancement, and reactivation, and also plan to bring recommendations to the board in May of 2022 to begin to bring the licensure policy in alignment with these requirements. Lastly, this rule addresses clerical errors with respect to speech-language pathology licensure, and the State Board staff will conduct a rulemaking hearing between first and final reading. Happy to take any questions you may have.
Are there any questions for Mr. Durline?
Madam Chair, this is Bob Eby.
Yes, Mr. Eby.
Yeah, Michael, I've got a couple of questions here. First, under Rule 11.11, number 3, it says the foundational skills literacy, completion of an approved foundational literacy skills professional development course must submit required documentation demonstrating completion of one of these courses. This is to get their license. Does the individual just take the course, or do they have to pass an exam? Should we insert successful completion, or do you just take the course? Yeah, I've been in some courses where you get a certificate whether you sit in there or not. Is this something that requires an exam, or?
The currently approved option does, and I think it would be an appropriate revision to include the word successful completion. That's a good point.
Okay, good. Thank you. Well, then I will make that motion to include that. And then later on in number 8, it says you're evaluating the educator's previous teaching experience. When you're evaluating the previous teacher's experience, do you also evaluate their effectiveness, or how, when it says, or is it just the years of experience in there?
Just so I'm clear, are you referring to the endorsement exemption?
Yes, yes.
So one thing to note is this is not a change here for this recommendation. What I will say, endorsement exemptions, or otherwise what we refer to as waivers, are issued on an emergency basis. They're temporary credentials that are issued year over year. And these are items that the commissioner may consider each year when determining whether the department will issue an emergency credential. So the answer to that question, it actually varies. 2 years ago, we did have requirements that touched virtually all of these items. And then since the pandemic, those requirements have been relaxed.
That's helpful. Thank you. That's all the questions I had, Madam Chair, but I would propose that we do insert the word successful, demonstrating successful completion of one of those requirements.
You're proposing an amendment. Is that the way
Yes.
we interpret that, Angie, Ms. Sanders?
Well, Bob, since this is a first reading item, we can just commit to making that change and bring it back to you on final reading. That way you don't have to do a roll call on the amendment.
Perfect. That's
Very good. Thank you. Other questions?
Madam Chair, Nick Darnell.
Yes, Mr. Darnell.
Michael, maybe you can help me understand as far as the professional development is the only way to gain that professional development through the state offered opportunity?
I believe the answer to that is currently yes, but I think the way the law is constructed is that it's opened up to the possibility that there could be other opportunities developed in the future. They would just have to be approved by the department.
Okay. We had a situation come up this week with a retired teacher. Her license is getting ready to, it is up for renewal this coming year. And so we're in the process of trying to help her. Of course, she is certified. Part of that is K3, so she would have to go through this process. Is the professional development opportunity offered to any licensed Tennessee teacher who that would fit K3?
One point of clarification, though, if her license expires this August, this provision would not apply to her. This law goes into effect August 1st, 2023. And so, she will have to apply to renew her license prior to this coming August. And if it's a professional level license, it would be valid for another 6 years. The answer to your second question, though, I believe is yes. It's accessible for any teacher who could potentially teach K3.
Okay, thank you. Because as most of us in education know, the retired teachers have been a great source of help. So we want to make sure that their licenses stay good. But thank you for that information.
Other questions? Mr. Morrow?
Yes, thank you. This is just a quick question. So right now, all the professional development you said is through the department, and so approving your own PD for the teachers who want to go this route. But you said the law opens up for if other districts want to develop their own professional development opportunities. Is that correct?
I believe, and Jack, feel free to jump in here if you know this better than I do, but I believe it's just worded that it would be department approved PD.
Okay.
It does not necessarily cite that districts could offer it or
Just department approved. It could be any, I mean,
believe that is correct.
Is there I guess an evaluation rubric that is public where, everybody can see how to go about getting approved professional development?
That goes a bit beyond the scope of my knowledge. We've been partnering really closely with the Office of Academics, so I'd be happy to go back to them, get a response on that question, and come back to you all.
Because just and why I'm asking, and it sort of stems from the initial question on making sure that we there's a successful completion of it. So there's a metric for achievement, or demonstrating mastery from the professional development, but also just wanting to have some level of quality control. As you open up channels for accessibility, which are very important, especially with, like what Nick's talking about, like you want to have accessible channels for people to remain certification. There's that creates a greater necessity for there to be a high level of quality control where we can ensure there is a consistent level of mastery in these areas for our teachers, so that we're making sure we still have students are getting the quality they need out of the PD that their teachers are having. So that's why I bring that up as would love to see, here's how we approve professional development. What's it say? Approve foundational literacy skills PD. Like, so what does a PD offering have to have in order for it to be approved?
Yeah, that makes a lot of sense, and I'd be happy to go back to our teams at the department to discuss that.
Awesome. Thank you.
Other questions? Hearing none, is there a motion to approve this item?
Ms. Gordon Ferguson, move for approval.
Mr. Ferguson provides the motion. Is there a second?
Bob Eby seconds.
Mr. Eby provides the second. Is any further discussion? Hearing none, Mr. Griffin, would you please call the roll?
Mr. Cobbins.
Aye.
Mr. Darnell.
Aye.
Mr. Eby.
Aye.
Mr. Ferguson.
Aye.
Mr. Hamby.
Aye.
Mr. Jensen. Ms. Kim.
Aye.
Mr. Mullenauer.
Aye.
Mr. Morrow.
Aye.
Madam Chairman?
Aye.
Madam Chairman, you have 9 ayes.
The ayes have it, and the motion is approved. Thank you, Mr. Durline. The next item, 3G, strategic compensation, Ms. Martha Moore.
Martha, you're still on mute.
Can you hear me now? Pardon me. Good morning, Madam Chair and State Board members. I am Martha Morris, Senior Director of Educator Effectiveness, and I'm here to present on Strategic Compensation Policy 5.600. Pursuant to TCA 493306 and the accompanying State Board rule, each LEA must adopt and implement a differentiated pay plan to aid in staffing hard-to-staff subject areas in schools and to attract and retain effective teachers. Strategic Compensation Policy 5.600 outlines the criteria for the approval of differentiated pay plans by the Tennessee Department of Education. According to the policy, districts are required to submit vacancy data as an addendum to their plans. This item seeks to add clarification to the language around differentiated pay plans and the timeline by which vacancy data must be submitted to ensure the data collected are accurate and useful for both the department and districts. Specifically, it's important to identify vacancies that exist after the school year is underway and therefore are detrimental to student outcomes. Additional changes include further explanation in the component criteria section to ensure that expectations for district implementation are clear. District pay plans must include at least one component from the following 3: hard-to-staff roles in schools, instructional roles and responsibilities, and performance. Should the district selected component for implementation result in no payout for 2 consecutive years, the department will require the addition of a second eligible component until a payout occurs. This revision ensures district meets the requirements of TCA 493306. Additional revisions include clerical changes for consistent terminology throughout the policy. At this point, I would be happy to take any questions.
Are there questions for Ms. Moore? I can say we certainly had a very thorough discussion yesterday, an excellent presentation by Ms. Moore. So let's see if there are any questions and follow-up that you want to interject today.
Madam Chair, Bob Eby.
Yes, Mr. Eby.
Yeah, I thought yesterday's presentation was very, very helpful, and thank you for that. I did have one question. You had mentioned, the 3 areas, and as I recall, you made some comment that they'll use a lot for the instructional component or something, so they don't leave any money. So they use all their money. My question is, do any districts ever leave money on the table?
We have had situations where districts write a plan with a single component. Typically, that's a hard-to-staff component, and they do not use that component. What we try to avoid single component plans. So when we receive one, we reach out to the district and have a phone call and talk through that and the implications of not paying out. So yes, it does happen that on occasion a district will write a plan that they don't actually implement, and they do leave money on the table. That is not the intent of the policy nor the law. So that's one of the things we are working toward avoiding. And we do work diligently with districts to ensure they have a plan that they can actually implement.
Thank you. As a follow-up to that, though, obviously one of the intents is to fill these hard-to-fill positions.
Yes, sir.
And so, I would hope that at the end of the day, the districts will work hard to fill those positions as opposed to using that money someplace else. Now, I think you allow money to carry over for a year or 2 years or something like that. Is that correct, or how does that work?
So the districts actually allocate their own money. We do not fund this, so they are moving their own monies around. But to answer the question you're asking, yes. If a district has a plan that they can't implement 1 year, so let's say they have a particular hard-to-staff area that they cannot fill in year 1, and they work to fill it in year 2, we would allow that to carry over. So if they really wanted to submit the same plan without a backup component or a second component, we would let them do that. And then after 2 years of non-compliance, we would then require them to implement a second component until they were able to pay out.
And I think you said that you hope to start getting data on those hard to fill positions to be able to track to see if they are being filled or not. Great.
Yes.
Thank you.
We are on our third collection, so at this point we will be able to start predicting trends, and the more often we have that vacancy data, the more accurate our trend prediction will be. So we are hoping moving forward that those two items will mesh well, and we will be able to help districts identify where they need to allocate that money.
Thank you.
Other questions or comments for Ms. Moore?
Madam Chair, this is Mullenauer.
Yes, Mr. Mullenauer.
Thank you, and I'll emphasize again, excellent presentation yesterday. It was very, very informative. I had one comment, and this is a conversation that I had with board staff in advance of this meeting today. There's some language in subsection 3.1A1. Again, that's 3.1A1 that I think leaves some ambiguities. I realize that that's not a subsection that's being proposed here. However, going back to your previous comments, Ms. Moore, the goal is to bring clarity for all stakeholders. So I talked with board staff, and they agreed to talk with the department about trying to clarify some of the language in that particular subsection. I'm assuming that this is something that we can do between now and final reading, but I wanted to at least bring that up and make sure that it was on everyone's radar. Thank you.
It is. We have talked about that, and those are some edits we can make between first and final read.
Thank you, ma'am.
Other questions or comments before I add one myself? As well, I did report to the staff that I thought that there was some language ambiguity that needed to be clarified as well. I would expect that that might have been submitted to you, and it's on, just so you know, it's on page 2 of the red line version, item D, lines 5 and 6, where you're talking about the TDO, that the TDOE will not approve a plan if it's in the first year where there are not eligible educators prior to approving. So I'm not saying that exactly correctly, but again, I believe you have that information. If not, I would ask the staff to send that to you and make sure that before the final reading that there's clarity there, because there's no way you could approve a plan because there have to be educators that are eligible for it in advance of your approval. How could you know that before they actually implement it? So that's where the issue is. So
thank you. We will work on that language and have had some conversation about that.
Excellent. Thank you very much. Other questions or comments? Hearing none, is there a motion to approve this item?
Madam Chair, Bob Eby, so moves.
Mr. Eby provides the motion. Is there a second?
Jordan Mullenauer, I second.
Mr. Mullenauer provides the second. Any further discussion? Mr. Griffin, would you please call the roll? Are you on mute, perhaps?
Sorry, it didn't let me buzz in. Mr. Cobbins.
Aye.
Mr. Darnell.
Aye.
Mr. Eby.
Aye.
Mr. Ferguson. Mr. Ferguson.
He had to leave briefly. He'll return. Thank you.
Mr. Hamby.
Aye.
Mr. Jensen. Ms. Kim.
Aye.
Mr. Mullenauer.
Aye.
Mr. Morrow.
Aye.
Madam Chairman.
Aye.
Madam Chairman, I count 8 ayes.
The ayes have it and the motion is approved. Thank you very much. And we will move on to item 3H, Special Education Program and Services Rule. Mr. Taylor Jenkins.
Good morning, Madam Chair and members of the board. My name is Taylor Jenkins, and I'm a staff attorney at the Department of Education. I am here to present on first reading proposed changes to Chapter 0520, 01, 09, Special Education Programs and Services. There are 2 proposed changes to rules in the chapter. First, we proposed adding a provision to Rule .05, which will state that special education eligibility determinations shall be completed within 60 calendar days of receipt of parental consent for an initial evaluation. Under federal law, an initial evaluation for special education must be completed within 60 calendar days but the eligibility determination must only be completed within a reasonable amount of time afterwards. Nonetheless, it has been long-standing practice in Tennessee for LEAs to complete both the initial evaluation and the eligibility determination within those 60 calendar days. The proposed change to Rule 0.05 simply codifies that practice, and the proposed change will therefore help ensure the timely provision of services to students with disabilities. Second, we propose adding a clarifying provision to Rule 0.15. The rule currently states that an LEA must notify a student's parents at least 10 calendar days before an IEP meeting to ensure that the parent has an opportunity to attend the meeting. The proposed clarification will simply note the student's parents and the LEA can mutually agree to hold an IEP meeting within that 10 calendar days. At this point, I am happy to answer any questions you have about the proposed changes.
Are there any questions for Mr. Jenkins? Hearing none, is there a motion to approve this item?
So moved, Daryl Cobbins.
Mr. Cobbins provides the motion. Is there a second?
Second, Nate Morrow.
Nick Darnell.
Nick Darnell.
I believe I heard Mr. Morrow first, provides the second. Mr. Griffin, would you please call the roll?
Mr. Cobbins,
Aye.
Mr. Darnell,
Aye.
Mr. Eby,
Aye.
Mr. Ferguson, Mr. Hamby,
Aye.
Mr. Jensen, Ms. Kim,
Aye.
Mr. Mullenauer,
Aye.
Mr. Morrow,
Aye.
Madam Chairman?
Aye.
Madam Chairman, I count 8 ayes.
The ayes have it and the motion is approved. Thank you, Mr. Jenkins. Item 3I, Career Exploration, Awareness and Advising Course Standards. Ms. Deborah McNall.
Thank you, Madam Chair and members of the board. Good morning. Very happy to be here today. I am Deborah Knoll, Senior Director of the Career Readiness in the Division of CCTE for the Department of Education. Today, I'm presenting to you on first reading the Career Awareness, the Career Exploration, and the Career Advising and Planning Course Standards. This item includes a revised Career Exploration course, as well as additional 2 new courses, the Career Awareness and Career Advising and Planning. All courses have been created in collaboration with post-secondary faculty, industry representatives, and middle school counselors. These courses are a progression of courses for grades 6th, 7th, and 8th. They include experiences providing students the opportunity to deepen their awareness of their individual strengths, values, and educational goals as it relates to the college and career readiness. Additional feedback will be solicited between the first and final reading if approved. These changes will go into effect in the 2022-23 school year. The Department of Education recommends acceptance of this item on first reading, and the State Board of Education staff concurs with this recommendation. Thank you so much for your time this morning, and at this time, I'd be happy to address any questions that you may have.
Are there any questions?
Madam Chair, Bob Eby.
Yes, Mr. Eby.
First, I'm really happy to see this. It ties into the goals for the master plan of the state board with regard to having a plan for the students going forward. But one question I have is courses have to accredit, which means they're going to be pretty extensive from a time standpoint. Do we have feedback from the districts that they're going to be able to include this within the schedule? That they're going to be able to include this in their schedule without impacting any of the other courses, or how do we fit in a 1/2 to 1 credit in there?
Yes, really great question. And so just for clarification, it's really going to be up to the district as to how much credit that they're going to approve for this course. We just give a recommendation, but it does vary by school. It will vary by district depending on their scheduling needs and the capabilities. However, what the feedback that we received from schools when we were creating these courses, as they could teach this content as part of a 9-week rotation, they could also embed it in part of their enrichment time or a homeroom time as well. So there's a lot of different ways that schools can incorporate this content into their day.
Thank you.
Welcome.
Other questions or comments? I have several, but I do once again want to give other members an opportunity.
Thank you, Madam Chair. This is Gordon Mullenauer.
Go ahead.
Just a couple of questions. Well, one question and a couple of comments. The question is, in reading through the material that's been presented, I did not see reference made to entrepreneurial endeavors, access to, or exposure to non-traditional career paths. Again, this is something we had talked about with staff in advance of this meeting today, but I just want to make sure that the department had that on the radar and wanted to understand, is there a reason why we would not want to also emphasize or assist children in exploring entrepreneurial opportunities as opposed to just specific predefined career paths?
Great question as well. We do have an entrepreneurship course that is offered independently of this, not for middle school, more for the high school. However, that's a great comment, and it's something we can take into consideration between first and final reading and to incorporate some of those items. Okay,
thank you. That will address a couple of my comments. The last comment that I would make is, I am the new member, so I'm still getting familiar with the work that everyone on this broader team does. I've been very, very impressed so far with how meticulous everyone has been. I did notice a handful of formatting and typos in this particular document. I realize that it may have come quickly amidst lots of other things and deadlines. I will circle back to the department to address those, but just wanted to say that A, I appreciate how meticulous the team is, and B, I think we all understand the importance of maintaining that discipline because as a broader team, we want to make sure that we're always presenting our best and most carefully presented policies and presentation to all the stakeholders that might be observing us. And the more professional and disciplined and meticulous we are, the better we'll be. So thank you.
Understood.
Excellent comments. Questions from any other member before I go to mine? Okay, I very interested in knowing how teachers are prepared to teach these courses, and if that's something that the department provides from a professional development standpoint, or if the LEA will do that or provide that training themselves.
Great question. So we will ensure that educators are well prepared to teach these standards in the classroom starting in the 2023 school year by providing in-person and virtual professional development options. So some of these offerings will include, we have the Summer Institute for Educators in the summer. It's held every July. It's a week-long professional development opportunity. So we will provide some sessions during that time. Another opportunity would be the SCALI conference, and this is a conference for school counselors. We will also be presenting some professional development there, as well as hosting virtual professional development housed on the Best for All platform for the Department of Education.
Excellent. Thank you so much for that. And I do want to note, and you may have received these comments from me already through the state board staff, there are some links that are embedded in each of those standards. And there are a couple of them that seem to be inactive, or they take you to a page that says 404 cannot load. So that's one thing. And I'm happy to submit that back. But if you all just check the links yourself, I think you'll see what I'm talking about. And then the other thing is under career exploration. That's a link that takes teachers to work-based learning. And I understand that work-based learning is a particular class that educators take so that they can teach work-based learning in the high school. So just wanted to understand if teachers who are not familiar with work-based learning, especially in 6th, 7th, and 8th grade, how might they utilize that, or are they expected just to go in and kind of tool around and pull out from that what they think may be effective for their purposes? Is that what you all are thinking?
Yeah, so great question. So this statement actually in that informational grid is actually provided on all of our CTE course standards. And the reason why we include that link is that when it takes the educator to that site, there's something called the Work-Based Learning Toolbox on there, and it offers some really great resources. In particular for these courses, There's things like the elevator pitch activity that educators can utilize as part of the standards. There's an employability skills checklist. There's an informational interview guide. There's a portfolio rubric and skills interview guide. So there's a lot of different resources for educators to utilize for these courses.
Excellent. Thank you so much. And I do want to add that I am extremely excited that you all have recommended these standards for this grade level, in particular because of the work that I had an opportunity to be engaged in while I was still working. And this is just right up the alley, and I believe it's the right thing to do to make sure that as soon as possible, students are having this type of exposure before they get to high school and before they decide to make their program of study choices. So kudos and compliments to you, because this is excellent work. So thank you so much. Other questions?
Thank you, Madam Chair.
You're welcome. Other questions or comments? Here, excuse me. Hearing none, is there a motion to approve this item?
This is George Mullenauer. I make the motion.
Mr. Mullenauer makes the motion. Is there a second?
Nick Darnell, second.
Mr. Darnell provides a second. Any further discussion? Mr. Griffin, will you please call the roll?
Mr. Cobbins,
Aye.
Mr. Darnell,
Aye.
Mr. Eby,
Aye.
Mr. Ferguson, Mr. Hamby,
Aye.
Mr. Jensen, Ms. Kim,
Aye.
Mr. Mullenauer,
Aye.
Mr. Morrow,
Aye.
Madam Chairman?
Aye.
Madam Chairman, you have 8 ayes.
The ayes have it, and the motion is approved. I'm inclined to take a 10-minute break here in between first and final reading. So let's reconvene at 10:26. Thank you very much. We will get started in 1 minute. As we reconvene, let's move into action items on final reading, beginning with item 4A, LEA Training Program Rules, Dr. Amy Owen.
Thank you, Madam Chair. Amy Owen, Deputy Executive Director for Policy and Research with the State Board. This item brings the State Board into alignment with Public Chapter 571 of 2021, which requires the State Board to create a process for LEAs to develop teacher training programs. Now, there's a lot going on in the EdPrep space, so I want to be clear about what this option is. We already have a pathway for an interested district to become an approved EdPrep provider in Tennessee, which should make them just like any college or university that can provide someone with training to earn initial licensure in Tennessee. So far, Rutherford County and Knox County have an approved EPP specifically for CTE occupational areas. So they could take someone in their community who was a welder or an auto repair and help them get their CTE teaching license for the first time. This program is a little different. This is about LEAs creating programs to help their currently licensed educators obtain additional endorsements. Now, depending on what areas a teacher's license covers, they can already add some endorsements simply by taking a praxis exam. So for example, I have a middle and high school history license. If I took an exam in sociology and I passed it, I could add that to my license. However, there are certain areas like special education, English learners, or going from secondary to elementary or elementary to secondary that require teachers to currently go back to an EdPrep provider to take coursework and then take the relevant exam. These rules establish a pathway for the districts to provide the training to their teacher rather than necessarily going back to a college or university prep provider. The educators who participate would have to have a professional level license, and they would still have to pass the relevant licensure exam at the completion of their course. The State Board held a rulemaking hearing on this item on December 16th of 2021. We also received feedback from the Tennessee School Boards Association that we were able to incorporate. Their suggestion was to add additional types of organizations that the LEAs could partner with to help develop their training content. But again, that's permissive. They can choose to partner with an organization like an approved EPP, but they do not have to. They could develop it in-house. The law is scheduled to take effect this coming July 1st, and I think we're on a good timeline to have the rules in effect by then, should you approve them today. So would you like to ask any questions about this item?
Are there any questions for Ms. Owen, Dr. Owen? I know we've had lengthy discussion about this in the past. I don't know about the other members, but of course I do continue to get some input from EdPrep providers expressing their concern that we ensure these pathways, alternate pathways, provide as much rigor as the EPP does, because this is certainly uncharted waters for us in the past. And so that continues to be a theme. And I believe that what we're approving, or what we have approved on first reading and on second reading, that does include all those elements to ensure the rigor.
We did work closely. Sorry.
Go ahead.
We did look at the EdPrep rule as we were developing the requirements that LEAs would have to meet in terms of ensuring that the people teaching the courses have relevant experience and credentials, that there's rigorous content, that they have a clinical mentor who's of a certain caliber. And again, they do still have those licensure exams at the end as a final check mark on their preparation. So I hear that concern. We definitely hear that as staff from EdPreps as well. But in order to comply with the law, this was the best pathway we could find moving forward that gives the districts the option and the flexibility while maintaining as high a bar as possible.
Exactly. I understand. Any other comments or questions? Hearing none, is there a motion to approve this item?
Bob Eby so moves.
Mr. Eby provides the motion. Is there a second?
Second, Daryl Cobbins.
Mr. Cobbins provides a second. Any further discussion? Mr. Griffin, will you please call the roll?
Mr. Cobbins,
Aye.
Mr. Darnell,
Aye.
Mr. Eby,
Aye.
Mr. Ferguson, Mr. Hamby,
Aye.
Mr. Jensen, Ms. Kim,
Aye.
Mr. Mullenauer,
Aye.
Mr. Morrow, Mr. Morrow. Madam Chairman?
Aye.
Madam Chairman, I count 7 ayes.
The ayes have it, and the motion is approved. Thank you, Dr. Owen, and you have the next item, statewide dual credit course approval, World History Standards.
Thank you, Madam Chair. This is an item to add an approved statewide dual credit world history course and to revise the standards for that course as well. Now, as we heard yesterday at the workshop, we had a presentation from the Tennessee Board of Regents about the statewide dual credit pathway. These are early post-secondary opportunities for students that have a program of study. The standards are developed by the higher education faculty, but they are taught by high school teachers. So this makes it in some ways more accessible to students than potentially some other options. The World History course has actually been in existence for a number of years. It was frankly an oversight that it was not added to the approved high school courses policy, but we will correct that later this meeting. However, we are looking today at revised standards for the course. The Tennessee Board of Regents convened a group of faculty from a number of institutions to make proposed improvements to this course. They're also looking for compliance with recent statutes around how certain concepts are taught in social studies courses as well. So we are ready to move forward today with the World History course, with the State Board staff recommending it for approval. A number of other statewide dual credit courses are still having some final touches from the higher ed side, and we anticipate having even more courses with revised standards coming your way for the next quarterly meeting. And I'm happy to take questions you might have on this item.
Are there questions for Dr. Owen? Hearing none, is there a motion to approve this item?
So moved, Daryl Cobbins.
Mr. Cobbins provides the motion. Is there a second?
I second, Jordan Mullenauer.
Mr. Mullenauer provides the second. Mr. Griffin, would you please call the roll?
Mr. Cobbins,
Aye.
Mr. Darnell,
Aye.
Mr. Eby,
Aye.
Mr. Ferguson, Mr. Hamby, Mr. Hamby,
I believe he's muted, and I thought I heard his aye a moment ago.
Mr. Jensen, Ms. Kim,
Aye.
Mr. Mullenauer, Mr. Mullenauer,
He's there and he's speaking, but I think he's muted.
Yep. Aye. Thank you.
Mr. Morrow.
Aye.
Madam Chairman?
Aye.
Madam Chairman, you have 7 ayes.
The ayes have it, and the motion is approved. Item 4C, Special Education Programs and Services Rule. Mr. Taylor Jenkins.
Good morning, Madam Chair and members of the board. Again, my name is Taylor Jenkins, and I am a staff attorney at the Department of Education. I am here to present on final reading proposed changes to Chapter 520.01.09, Special Education Programs and Services. Changes to this chapter were presented on first read at the October State Board meeting. Afterwards, State Board staff held a rulemaking hearing in December to gather public feedback. 2 organizations submitted a total of 4 comments, and I am happy to summarize those comments and the responses First, Rule 0.2310B, Rule 0.2310B requires LEAs to submit a copy of any restraint or isolation report to the department within 5 calendar days of the incident occurring. A commenter requested changing the timeline to longer than 5 calendar days, but the department declined that request because there was no student-centered reason for shortening the timeline. Since the use of restraint or isolation can implicate safety concerns for both students and staff, requiring LEAs to report instances of restraint and isolation within 5 calendar days ensures that both the LEA and the department review and approve all reports in a timely manner, and that any issues in administering restraints and isolations can be corrected quickly. Second, Rule 0.242 states that functional behavioral assessments shall be led by a school personnel member trained to conduct FBAs. A commenter requested adding a requirement that the training be provided by the department or by a department-approved vendor, but the department declined that request. While the department currently does provide free training on FBAs and BIPs through a partnership with Triad, it is not the department's practice to require that training be provided by the department or by a department-approved vendor. Third, Rule 0.247H states that a behavior intervention plan shall include a description of the consequences or strategies required when challenging behavior occurs. A commenter noted that the word consequences could have a different meaning for educators and lay individuals. For educators, the word consequences means a response to a challenging behavior. But for lay individuals, the word consequences could have been interpreted as disciplinary action. To ensure that the intent of the rule was clear to all audiences, a change was made to signify that the word consequences simply means a response to challenging behavior. And finally, Rule 0.2410 was added in response to a comment. Rule 0.2410 notes that nothing in the chapter prohibits an LEA from developing an informal behavior plan for a student when the student's behavior does not rise to the level of requiring a formal behavior plan. At this point, I am happy to answer any questions you have about the proposed changes or about the responses to public comments.
Are there any questions for Mr. Jenkins?
Nate Morrow, I have a question.
Morrow, please proceed.
Thank you. Who is responsible then for the FBA professional development, and how are districts resourced in a way to be able to provide that appropriate training?
Training is required, and currently the department provides a popular free training through the Tennessee Technical Assistance Network that is led by Triad, a group out of Vanderbilt. So while we expect that many LEAs across the state are attending that training, we did not want to impose that on every LEA. I am unaware of other trainings that are available, but it is certainly possible that LEAs are attending trainings other than those hosted by Triad.
And is there a requirement for a consistent approach in the different trainings? So, I mean, you guys are familiar with Triad, so they're doing it in a specific way. There's a specific, set of principles they're trained to and adhering to and educating towards. If a district elects not to use what you all are familiar with and chooses to go in a different direction for FBA training, is there a requirement that do they have to get that training approved by the State Department first, or can they just go do whatever they choose with FBA training?
Right, I understand the question. No, there is no requirement about what the training entails or who provides that training. My understanding is that is not a common practice to require what a training entails.
Okay.
Other questions? Hearing none, is there a motion to approve this item?
Bob Eby moves for
So
approval.
moved.
Mr. Eby provides the
Second,
motion.
Darrell Coppins.
Mr. Coppins provides the second. Any further discussion? Hearing none, Mr. Griffin, would you please call the roll?
Mr. Cobbins,
Aye.
Mr. Darnell. Mr. Darnell,
He's there. Are you speaking,
Aye.
Darnell?
Mr. Eby,
Aye.
Mr. Ferguson, Mr. Hamby,
Aye.
Mr. Jensen, Ms. Kim,
Aye.
Mr. Mullenauer,
Aye.
Mr. Morrow,
Aye.
Madam Chairman.
Aye.
Madam Chairman, you have 8 ayes.
The ayes have it and the motion is approved. Thank you, Mr. Jenkins. Moving to item 4D, STEAM Standards Framework for grades K-5. Ms. Deborah Knoll.
Thank you again, Madam Chair and members of the board. Good morning. Again, I'm Deborah Knoll, Senior Director of Career Readiness in the Division of CCTE for the Tennessee Department of Education. I am presenting to you on final reading the K-5 STEM STEAM standards. This item includes new and revised K-5 STEM STEAM standards that have been created in collaboration with post-secondary faculty, industry representatives, and K-5 teachers. This course is a foundational course experience, providing students the opportunity to deepen their understanding of the content connections that exist between science, technology, engineering, the arts, and mathematics. If approved, these changes will go into effect for the 2022-23 school year. In response to feedback from CT directors, district STEM consultants, educators, and the Tennessee STEM Innovation Network, these new and revised K-5 STEM STEAM standards provide a stronger foundation to lead to and align with secondary coursework options and provide expanded post-secondary pathways, incorporate added instructional rigor, and reflect the competitive employment demands of our state. The standards are also designed to align with the attributes of the STEM STEAM designation rubric. Between first and final reading, revisions were made to be more consistent in the reference to the arts to reflect the continuity of the integration of STEAM throughout the course standards. The Department of Education recommends approval of this item on final reading, and the State Board of Education staff concurs with this recommendation. Thank you again for your time this morning, and I'd be happy to address any questions.
Are there any questions for Ms. Knoll?
Madam Chair, Bob Eby.
Yes, Mr. Eby.
It's not a question, but just a couple of comments. First, really glad to see the arts get in and make it STEAM throughout. But being an engineer, very glad to see STEM and STEAM being incorporated in K through 5. I think it's great. Thank you.
Great. Thank you.
Thank you, Mr. Eby. Other comments, questions? Hearing none, is there a motion to approve this item?
Bob Eby moves for approval.
Mr. Eby provides the motion. Is there a second?
Jordan Mullenauer, second.
Mr. Mullenauer provides the second. Any further comments or discussion? Mr. Griffin, would you please call the roll?
Mr. Cobbins, Mr. Darnell,
Aye.
Mr. Eby,
Aye.
Mr. Ferguson, Mr. Hamby,
Aye.
Mr. Jensen, Ms. Kim,
Aye.
Mr. Mullenauer,
Aye.
Mr. Morrow.
Aye.
Madam Chairman?
Aye.
Madam Chairman, I count 7 ayes.
The ayes have it and the motion is approved. Thank you again, Ms. Knoll. Moving to item 4E, Residential Mental Health Facilities Rule, Mr. Scott Intermel.
Good morning, Madam Chair and members of the board. Thank you for yesterday's opportunity.
We are having some technical difficulty hearing you. Or is it just me?
No, I think it's everybody.
Okay, let's try that again. Maybe it's a volume, but it was a little bit staticky too. Cannot hear you.
Do you want to try one more time? And if we can't hear you, I'm wondering if we have Jack Powers or Robin Ye from the department available.
This is Jack. I'm available. Let me just take one moment to pull the item up. And maybe Scott is able to work on his volume or his sound issues. Okay. Scott, you're really quiet. I'll tell you what, I can go ahead and present the item, and then Scott, maybe you can keep kind of working on your volume, and then if board members have questions, hopefully you've potentially worked it out and we can go from there. How does that sound?
Thank you, Jack.
Got it. Okay, so just a little bit of background on this item. We're presenting on second reading revisions on the residential mental health facilities rule. Tennessee Code Annotated governs when in-house students and local funding is allocated to licensed residential mental health facilities when Tennessee students are admitted. The statute was amended by Public Chapter 589 of the Public Acts of 2021 to authorize funding to be allocated to certain out-of-state residential mental health facilities when Tennessee students are admitted and certain conditions are met. Specifically, Public Chapter 589 directs the State Board of Education to promulgate rules to establish procedures for approving educational programs or instructional services provided by out-of-state residential mental health facilities and for the allocation of funds. And so what this item is doing is it is creating a new residential mental health facilities rule that is stemming from the specific requirements in Public Chapter 589. The rule establishes 13 conditions, all of which are directly copied from Public Chapter 589 that must be met in order for an LEA to transfer BEP funds to an out-of-state residential mental health facility. The conditions include, but are not limited to, the student being admitted to the facility under a signed order based upon medical necessity. There are no in-state facilities with the capacity to deliver the appropriate treatment to the student, and the out-of-state facility is in a bordering state, which has served at least 15 Tennessee students per year and meets comparable educational health and safety requirements. The State Board staff held a rulemaking hearing on this item on December 16th and did not have any comments. We did make some revisions between first and final readings stemming from some of the board members' input. That includes having a definition of capacity to mean a bed available at a Tennessee residential mental health facility to provide the appropriate mental health support. In addition, we added some revisions to further detail what the appeals process would look like should an out-of-state facility lose its approval from the department due to noncompliance. And so with that, I will pause for a moment, and we certainly welcome questions. I know that we've got Scott maybe trying to work out his audio, but we've also got Taylor Jenkins on, and I'm also happy to take questions if board members have it.
Thank you, Mr. Powers. I do want to point out, and the board members know this, we had an excellent presentation yesterday by Mr. Intermel, and he did an excellent job of clarifying the changes from first reading to second reading. And so with that, I certainly want to compliment him again and ask if any of the board members have any questions, especially after the great job he did yesterday. So,
Madam Chair.
Yes, is that Mr. Morrow? Or Mr. Mullenauer? Thank you.
Thank you. I would echo your comments. Mr. Intermel did an excellent job yesterday of answering a number of questions. Thank you, Scott. I know you can't talk to us right now, but thank you. The only comment that I would make is, I hope that our inquiry of you, Mr. Intermel, yesterday was taken the right way. Our heart was to be mindful of those who can't speak for themselves. I know that the department works hard to that same end, but our interest as a board is to certainly help those who are well on their path to success, but also to be mindful of and caring about those who may not have a voice, even to express some concerns that they face, from childhood and on. So I appreciate the work that you guys do, and I just want to say thank you for your presentation yesterday.
Thank you for those comments. Mr. Morrow?
Madam Chair, I want to echo the exact same thing. Phenomenal presentation. Thank you for the, continuing to communicate the complexities of this. And, my only request was if there would be a way that we could, we spoke all yesterday in a number of hypotheticals with what happens if, right? Is the insurance company going to drive this, or what happens if the parent doesn't have a voice? Or, how are we going to do that? And there's no way to know. And so I was just wondering if there'd be a way that we could have a update as we go along to sort of, is our fear unnecessary, or is that a real concern that we need to continue to contend with when it comes to those without insurance or those without a lot of the advocates in a student's life that some others may have. And so I just would love to try to, it's a phenomenal report. I would just love to see if we could see in the future how is this working.
Sure, absolutely. And my understanding.
I think we're still having some volume issues there, Scott. I am happy to chime in and answer that question, though. Mr. Morrow, certainly appreciate the question. We appreciate board members, especially yesterday, kind of proposing all those different scenarios. I think it's really important here just to keep in mind related to this concern that a lot of the questions and scenarios posed yesterday were within kind of this ecosystem of placement into mental health facilities that isn't being changed by this rule. There are students perhaps today who are attending or being placed in an out-of-state mental health facility because someone has deemed that is the most appropriate placement for them. And this rule is not changing the process by which that happens. It is just ensuring that there's a pathway for the transfer of those BEP funds. With that being said, the department can certainly commit, for one, to keep the board updated about the actual facilities that apply for approval through this rule, through the pathway that it does create. And of course, too, as our content area experts and folks on Scott's team continue their daily work with districts, we can certainly commit to filtering up any concern that we may hear should the issue of placement or any of the concerns that were raised yesterday filter up to the department. We can most certainly commit to keeping board members informed about that.
Madam Chair?
Yes. Please proceed.
Thank you, Jack. I would just say that, to the extent that these edits make funding more available or more readily available to facilities, those being out of state, mostly in this case, I would just say that to the extent that that those companies or those providers are attracted to provide those services, to the extent that they're on this call and happen to be listening, we would invite them to care for these kids. But I hope that they would also understand that everybody on this call, at least from the department and from the board, is watching closely, and we just want to make sure that these kids are kept safe. Thank you.
Thank you for those additional comments. Anything else? Any other questions for Mr. Powers, who is doing a great job filling in for Mr. Intimel? Any other questions, comments? Hearing none, is there a motion to approve this item?
This is Jordan Mullenauer. I make a motion.
Mr. Mullenauer provides the motion. Is there a second?
Nay Morrow, second.
Mr. Morrow provides the second. Any further discussion? Mr. Griffin, would you please call the roll?
Mr. Cobbins.
Aye.
Mr. Darnell.
Aye.
Mr. Eby.
Aye.
Mr. Ferguson. Mr. Hamby.
Aye.
Mr. Jensen. Ms. Kim.
Aye.
Mr. Mullenauer.
Aye.
Mr. Morrow.
Aye.
Madam Chairman?
Aye.
Madam Chairman, you have 8 ayes.
The ayes have it, and the motion is approved. Thank you once again. Moving on to item 4F, Charter School Authorizer Evaluations, 2021 Outcomes. Ms. Ali Gaffey.
Thank you. Good morning. Ali Gaffey, Director of Engagement and Accountability for the State Board. On final reading today are our 2021 Charter School Authorizer Evaluation Outcomes. Tennessee Code Annotated 49-13-145 charges the State Board with ensuring the effective operation of authorizers and evaluating authorizer quality. Our State Board approved evaluation rubric is aligned to State Board Policy 6.111, and our evaluation process is outlined in State Board Rule. Charter school authorizers are evaluated at least biennially, and the process includes a thorough review of documentation submitted by the authorizer, as well as interviews with school leaders, authorizing staff, six charter school authorizers: Hamilton County Schools, Knox County Schools, and Shelby County Schools. This item includes the 3 evaluation reports, which detail the ratings for each of our substandards, evaluative comments explaining the documentation used, and the rating, used to determine the rating rather, and providing feedback, an overall rating, and follow-up actions. So you are voting today to approve the overall ratings for each of the evaluated authorizers. Our authorizers did have an opportunity to review the evaluation reports prior to finalizing them, and they will be posted to our State Board website following your vote today. We do have 3 remaining authorizers who will complete their first round of evaluations this fall. That is the Achievement School District, Metro Nashville Public Schools, and the Tennessee Public Charter School Commission. And that cycle will repeat itself into the future. Happy to answer any questions.
I would like to jump in and add the comments that I made yesterday for the record today. The process that you have put into place with its rigor, the extensiveness of the details, the documentation, incredibly thorough and very rigorous. And so I want to thank you and compliment you for the great work. In particular, that since this is the first year that we're doing this, there may certainly be edits and revisions in the future, but what's been laid out for us thus far is just excellent work, very detailed, you did your due diligence, so thank you for that. Are there comments or questions for Ms. Gaffey?
Madam Chair, Bob Eby.
Yes, Mr. Eby.
At first, I would echo the comments that you made. I thought it was extremely thorough. One thing in particular I was really glad to see was the lessons learned and best practices and sharing those throughout the charter schools, because I think that's the way schools learn, is through that process. And also reiterate a comment that, you got 3 scores. I look forward in the future to seeing how those scores then correlate with performance of the charter schools. I think that's where the rubber will hit the road. But outstanding job done. Good start. Thank you.
Thank you. Other questions or comments?
Madam Chair?
Yes, Mr. Mullenauer.
I would echo the exact same thing and just say that this is obviously very important work to advance the initiative across the state. I hope that all participants understand your interest in the collaborative dialogue that you're trying to encourage here, and just want to say that you did a great job, as we discussed yesterday, not only of getting to this point, but also thinking well in advance in mapping towards that directive. So thank you so much.
Thank you. Very good. Other comments, questions? Hearing none, is there a motion to approve this item?
So moved.
Second.
Mr. Mullenauer, was that you? I apologize. Didn't he?
Yes, ma'am.
Mr. Mullenauer provides the motion.
Bob
Second.
Eby seconds.
Mr. Eby provides the second. Any further discussion? Mr. Griffin, will you please call the roll?
Mr. Cobbins.
Aye.
Mr. Darnell.
Aye.
Mr. Eby.
Aye.
Mr. Ferguson.
Aye.
Mr. Hamby.
Aye.
Mr. Jensen. Ms. Kim.
Aye.
Mr. Mullenauer.
Aye.
Mr. Morrow.
Aye.
Madam Chairman.
Aye.
Madam Chairman, you have 9 ayes.
The ayes have it, and the motion is approved. Thank you once again. Moving on to 4G, 5G, 4. why my numbering is wrong all of a sudden. 4G, Educator Preparation Providers and Specialty Area Programs, Dr. Annie Insana.
Thank you, Madam Chair and members of the board. Annie Insana, Senior Director of Educator Preparation at the department. The recommendations in item 4G are related to 4 comprehensive review outcomes that occurred in the spring of 2021 and 1 prospective EPP review outcome. In relation to the 4 comprehensive reviews, as brief context, there are 2 pathways for ongoing state approval for EPPs and specialty area programs. The National CAPE accreditation process facilitated through a CAPE state joint review and the state managed process. Reviews occur every 7 years and outcomes from these reviews are brought to our Advisory Committee on Educator Preparation, which is a committee of appointed LEA and EPP representatives that examine the accuracy and integrity across all EPPs and SAP reviews. There are 5 review outcome statuses outlined in State Board rule ranging from full approval exemplary status to denial of approval. The specific comprehensive review outcomes recommended today include 3 CAPE state joint reviews and 1 state managed review. Austin Peay State University CAPE state joint review team concluded that all CAPE standards were met with no deficiencies. The provider is recommended for full approval and full approval for all reviewed licensure programs. Belmont University's CAPE State Joint Review Team concluded that all CAPE standards were met with 3 areas for improvement. The provider is recommended for full approval, minor stipulations, and full approval for all licensure programs. Lemoyne-Owen College's CAPE State Joint Review Team concluded that 4 out of 5 CAPE standards were met with 11 areas for improvement and 2 stipulations. After review of the English and Math 612 programs, the team concluded that there were no deficiencies, and these programs are recommended for full approval. After the review of the early childhood and elementary programs, the team concluded that there were minor deficiencies, and these programs are recommended for full approval with minor stipulations. After review of the special education, K-12, and remaining secondary 612 programs, the team concluded that there were major deficiencies. Therefore, these programs are recommended for probationary approval with major stipulations. Welch College State Managed Review Team concluded that all CAPE standards were met. 4 minor stipulations were cited. This provider is recommended for full approval, minor stipulations, and full approval for all licensure programs. Once the outcomes are voted on, any EPPs that participated in a state managed review with the status of full approval with minor stipulations will engage in an action planning process focused on the areas of deficiencies as outlined by the review. This process is facilitated by the department. EPPs that participate in a CAPE state joint review with the status of full approval with minor stipulations or probationary approval with major stipulations will engage in regular annual reporting facilitated by CAPE. Further, EPPs with a probationary status would engage in a probationary status visit 2 years following the previous on-site review. Before turning it over to questions, there's one more recommendation for consideration, which includes the review of Sumner County's prospective EPP proposal. The iterative review of the prospective EPP is conducted by the department. The outcomes of the review indicated that Sumner County did not meet expectations on eligibility requirements or CAPE standard expectations. Therefore, Sumner County is recommended for denial of initial approval as a Tennessee EPP. Per State Board Educator Preparation Rule, if initial approval is denied, a prospective EPP may submit a revised proposal for consideration during the next review period. Happy to answer any questions you may have.
Are there any questions for Dr. Insana?
Madam Chair, Bob Eby.
Yes, Mr. Eby.
Yes, thank you, Dr. Insana. Just one question. Sumner County, which what you're recommending for denial, they can reapply. Is it clear to them where they were denied and what they will have to do to reapply and to pass, or what's the process there?
Yes, sir. So after the second round in garnering an initial approval or denial recommendation, Sumner County is provided with comprehensive feedback that targets the areas in which we're not meeting sufficient criteria. We have had subsequent conversations with Sumner County, and I know that they're eager to reapply, and we have offered technical support in that regard as well.
Great, thank you.
Other questions or comments? Hearing none, is there a motion to approve this item?
Nick Darnell, so move.
Mr. Darnell provides the motion. Is there a second?
Aaron Hamby, second.
Mr. Hamby provides the second. Any further comments or discussion? Hearing none, Mr. Griffin, would you please call the roll?
Mr. Cobbins,
Aye.
Mr. Darnell,
Aye.
Mr. Eby,
Aye.
Mr. Ferguson,
Aye.
Mr. Hamby,
Aye.
Mr. Jensen, Ms. Kim,
Aye.
Mr. Mullenauer,
Aye.
Mr. Morrow,
Aye.
Madam Chairman.
Aye.
Madam Chairman, you have 9 ayes.
The ayes have it and the motion is approved. Thank you, Dr. Insana, for your great work. Appreciate you being here again today with us. And we'll move on to the next item. The next two, actually, Dr. Owen, you will be covering those. The first one is approved high school policy. I will turn it over to you.
Thank you, Madam Chair. Amy Owen with the State Board of Education. This is item 3.205, the approved high school courses policy. This policy is simply a listing of every course that is approved for school districts to offer in grades 9 through 12 for high school credit. At the October board meeting, when we heard the statewide dual credit standard revisions on first reading, staff found that the statewide dual credit world history course had not in fact been added to this policy. However, it had been offered since 2016-17. So with the approval of the statewide dual credit world history standards on final reading today, we are making the addition or the proposed addition on first and final reading to add the SDC world history course to this policy. Of course, as we have other SDC courses and any other course standards that change, we will be sure to closely cross-reference this policy to make sure that all options are listed. That is really it. This item is usually on first and final reading because you have already seen the standards themselves on 2 readings. And this is simply taking the approved standards for the course and ensuring that the course is allowed to be offered. Do you have any questions on this item?
Are there any questions?
Madam Chair, Bob Eby.
Yes, Mr. Eby.
Dr. Owen, I know that all courses aren't offered everywhere, but do all the districts, maybe it's through Access at All or something, have the opportunity to provide all their students with each one of these courses? That makes sense.
It does. It's a good question. There's obviously so many courses here that a district with, say, 1 or 2 high schools would simply not feasibly be able to offer it in their scheduling and staffing patterns. So I know what many districts do, particularly for the CTE areas, the department, and they have support from their regional offices to look at what are the in-demand fields in their area, what should they prioritize offering, and they can change those over time. I'll tell you, when we at the state board look at standards review for math, science, ELA, and social studies, for those high school elective courses, we have recently been asking the department for data. We just did this for science on how many districts are actually offering physical science as opposed to environmental science or anatomy, or, to get a sense of how commonly used those elective courses are and whether any of them should either be revised or removed if there's simply not a lot of interest or uptake.
Thank you. It would be nice to know, because I know that certainly the rural districts don't have access to all the classes, and it would be nice to know what % of the classes that are there are being offered statewide versus not.
We can certainly ask the department to support us with that. They have the student enrollment system data that we don't have at the state board side, but happy to try to coordinate that.
Thank you.
Are there other questions or comments? Hearing none, is there a motion to approve this item?
Ms. Gordon Ferguson will move for approval.
Mr. Ferguson provides the motion. Is there a second?
Jordan Mullenauer, I second.
Mr. Mullenauer provides the second. Any further discussion? Mr. Griffin, will you please call the roll?
Mr. Cobbins,
Aye.
Mr. Darnell,
Aye.
Mr. Eby,
Aye.
Mr. Ferguson,
Aye.
Mr. Hamby,
Aye.
Mr. Jensen, Ms. Kim,
Aye.
Mr. Mullenauer,
Aye.
Mr. Morrow,
Aye.
Madam Chairman?
Aye.
Madam Chairman, you have 9 ayes.
The ayes have it and the motion is approved. Dr. Owen, just dive into the next one. Thank you.
Thank you, Madam Chair. Our final item on final reading is the approval of 2 requests from districts for textbook and instructional materials waivers. Since the summer of 2020, the State Board has had authority to act on textbook and instructional materials waiver requests from school districts. This is when they want to use textbooks or instructional materials for their full 180-day curriculum that are not on the state textbook approved list. The Department of Education, of course, has the subject matter experts on these topics, having a much more robust staff than we do. So their subject matter experts review the proposed materials for alignment to Tennessee standards and provide feedback on that information to the state board staff, and we then put together the recommendation. We have several requests from LEAs. Hawkins County is seeking approval for materials to use in their virtual school. Rutherford County is seeking approval for materials to use in their virtual high school. We looked at some of these waiver requests at the October board meeting for Rutherford County and also a Houston County virtual school. The department subject matter experts were able to review the math, science, and ELA requests at that time. They've now been able to provide us with information on the fine arts and music courses. And we do still have several outstanding waiver subjects from each of those districts that I mentioned. And we continue to work with DOE and their content experts to get final reviews and information for future action. But for today, the recommendation for Hawkins County was about their art appreciation and history course and about a music appreciation course, both from a vendor called Edmentum. The art history and appreciation course, the standards alignment document that the vendor provided showing how do their materials meet Tennessee standards in that subject were actually not aligned to the most updated, currently in effect standards for the subject. They were based on standards that were implemented prior to 2018. So that is not recommended for approval at this time. The music appreciation course that was provided did appear to meet the Tennessee academic standards for the subject, and so is recommended for approval for the waiver. Similarly, the Rutherford County program, the vendor there is called Graduation Alliance, and those are recommended for approval at this time, those waivers. The department had some guidance for the district on how to best code those courses in the enrollment system to make sure that students are earning the relevant credit, that they are recommended for approval at this time. So happy to answer any questions you might have. I know that this is still a newer topic for the state board to consider, but these waivers would be in effect until the next time textbooks are adopted for these grades and subjects. So the next time that the standards are updated and the textbook commission approves a new list, the LEA would either need to adopt off the state list at that time or request a separate waiver again.
Are there any questions?
Chair?
Yes, Mr. Mullenauer.
I did not see this on the agenda for second reading today. I may be looking at an older agenda. I'm going to, and it sounds like there's been previous comment and discussion on this prior to my time here, so I'm going to abstain from voting just because I'm not familiar with the material. Thank you.
And you will state that when you vote. Thank you.
He uploaded this, I'm afraid it was maybe January 27th or 28th, somewhere in there. But I certainly understand and apologize for not flagging it more clearly.
Other questions or comments? Hearing none, is there a motion to approve this item?
Bob Eby moves for approval.
Mr. Eby provides the motion. Is there a second?
Nick Darnell, second.
Mr. Darnell provides the second. Any further discussion or comments? Hearing none, Mr. Griffin, would you please call the roll?
Mr. Cobbins,
Aye.
Mr. Darnell,
Aye.
Mr. Eby,
Aye.
Mr. Ferguson,
Aye.
Mr. Hamby,
Aye.
Mr. Jensen, Ms. Kim,
Aye.
Mr. Mullenauer,
Abstain, thank you.
Mr. Morrow.
Aye.
Madam Chairman?
Aye.
Madam Chairman, you have 8 ayes and 1 abstain.
The ayes have it and the motion is approved. Thank you, Dr. Owen. Moving into items 5, teacher licensure action, Ms. Candace Carter and Mr. Alex Anderson.
Good morning, Madam Chair and board members. My name is Alex Anderson. I'm a staff attorney with the board. We're here to, Candace Carter is on the line with us, and we're here to answer any questions that you or the board members might have on the license discipline actions.
Are there any questions regarding items A through I, the list of actions? Hearing none, is there a motion to approve the entire list from A to I?
This is Mullenauer, so moved.
Mr. Mullenauer provides the motion. Is there a second?
Gordon Ferguson, second.
Mr. Ferguson provides the second. Mr. Griffin, would you call the roll, please?
Mr. Cobbins,
Aye.
Mr. Darnell,
Aye.
Mr. Eby,
Aye.
Mr. Ferguson,
Aye.
Mr. Hamby,
Aye.
Mr. Jensen, Ms. Kim,
Aye.
Mr. Mullenauer,
Aye.
Mr. Morrow. Mr. Morrow? Aye.
Aye.
Madam Chairman?
Aye.
Madam Chairman, you have 9 ayes.
The ayes have it and the motion is approved. Before we move into adjournment, as always, I want to recognize any member for any closing remarks that you may have at this time. Hearing none, I do want to make just another comment. As always, the presenters, thank you so much for the great work you do from the Tennessee Department of Education, the State Board of Education. This is great work on the behalf of Tennessee students so that we as a board can in fact do our best work in approving these items where appropriate. So without objection, we are adjourned and thank you very much. I hope you all have a wonderful weekend.
Thank you.
Thank you.